Did you get into a car accident that resulted in a DUI charge? Does it matter whether the collision was your fault? We're going to take those questions on in this video here. Hi everyone, Attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. It comes as no surprise that a lot of DUI arrests arise out of a traffic collision. And those collisions could be anything from a small fender bender to a really large crash that's maybe catastrophic. Some of them involve crashes with other cars, some of them involve crashes just with property or maybe falling off the roadside. And many different things contribute to a vehicle collision, not just impaired driving. Sometimes a crash happens because of an equipment failure. Sometimes it happens because another car actually comes over and causes my client to drive off the road or collide with somebody else. A recurring question I get in defending DUIs over several years is when a client comes to me and they say, well, that collision wasn't really my fault. The other driver caused that to actually happen. Or maybe it's just the bad weather or poor maintenance of the road. I could go on and on for all these other things that contribute to a vehicle collision. However, not all cases are created equal. And so this information might be relevant in some cases, might not be relevant or helpful in others. Let's start with the basics. Remember, going to my old friends, the California criminal jury instructions, look carefully at the instructions for the different types of DUI charges. You'll find those in the jury instructions that apply to Vehicle Code Section 23152 and the relevant subsections. In order to prove you guilty of a DUI, the government has to prove that you drove a car while either you were too impaired to drive safely because you were under the influence of a drug, alcohol, or combination thereof, or that you had an alcohol level in your system while driving that was over the legal limits. None of those have anything to do with whether a collision was your fault, or at least not outright. In some circumstances, you could find yourself driving over the legal limit of 0.08 and a collision occurs that's not your fault. Well, they still might have the defendant on a charge of DUI if they can still prove beyond a reasonable doubt that they were actually driving with a prohibited BAC level. Maybe they can also prove that the defendant was impaired even if the collision had nothing to do with alcohol or drug consumption. These are things that can often happen. So what if the question is more like, well, the police didn't really have the right to arrest me because the collision wasn't my fault? Well, that argument probably isn't going to get a whole lot of traction either. Under the Fourth Amendment to the U.S. Constitution, you have a right to be free from unreasonable searches and seizures. What we call the exclusionary rule to the Fourth Amendment says that when evidence is seized from you in violation of this constitutional right, that evidence could be suppressed. In a DUI case, for example, if a traffic stop happens illegally, then all the breath and blood samples could be suppressed for violating the defendant's Fourth Amendment rights. So let's apply this logic to a situation where somebody gets into a traffic collision that's not their fault. Well, in that situation, whether or not it's your fault doesn't really matter as to whether or not the police have a right to interact with you and escalate into a DUI investigation. After a traffic collision, police have very wide authority to contact anybody on the scene, at the very least to conduct what's called a welfare check to see if everybody's all right. If during that situation the police happens to observe indicia of impairment like the smell of alcohol, slurred speech, etc., and the defendant then agrees to participate in field sobriety tests, remember, you don't have to participate in those tests, but if you choose to do so, they're going to take their notes and make their observations. In those situations, that's really why an accident, not the defendant's fault, leads to a DUI arrest. So how the collision went down isn't really all that helpful in many ways, but it can be helpful in others. Remember, the government has to convince a jury at the end of the day, beyond a reasonable doubt, that the defendant drove with prohibited level of alcohol or that they were too impaired to drive safely based on their consumption of alcohol, drugs, or both. So, in a situation where the proof of impairment relies on multiple factors, how the collision went down might only be one of them. So the bad news is there's many different ways for the government to prove a DUI case. If they're still able to prove that you were reliably tested above 0.08, well, that's going to be a DUI, whether the underlying collision was your fault or not. However, it is worth noting how much time the collision eats into the underlying investigation. By its very nature, a collision makes the DUI investigation a little bit less regular than a traffic stop for, say, speeding. In those situations, the timeline of the arrest, the investigation, and clocking where somebody's BAC is are usually pretty tight. In a traffic collision, it may not always be totally clear when the actual driving occurred, and therefore when did the alcohol consumption occur, and when did that person actually cross a prohibited level of impairment or a prohibited BAC? When did they really cross .08? It might not be as clear in a collision case, or at least in every collision case, than in, for example, a routine traffic stop case, because it takes time for officers to notice the collision, to get there, and then get parties to the hospital or to a testing facility of some kind. Those things could compromise the proof of the case. Doesn't really have anything to do with who actually caused the collision or what contributed to it, though, so let's get on to that topic. Remember, take inventory of how the government can prove impairment, okay? So if the proof of impairment is based on multiple different factors that are very persuasive, other than the collision, well, the fact the collision might not have been your fault might not really be your best weapon to fight the case. But in a case where maybe the alcohol testing is sketchy because it's close to the margin of error, or because there might have been some contamination, the field sobriety tests, which again, we advise you don't do, but there may not be as scientifically sound in the eyes of the jury, or maybe your performance on the field sobriety tests are otherwise satisfactory. And if the underlying collision is what the DA is using to hang their hat to prove that you were actually committing a DUI, well, what actually contributed to the collision? Was the collision more to do with factors other than impairment? If so, bringing that issue up might result in a perhaps better sentence or a better offer in that case if you want to negotiate the matter. Or if you want to take the matter to a jury trial instead, proving up information about how the collision went down could be very persuasive to that jury. I would definitely leave by saying that if you are going to trial in a DUI, all proof of how the collision went down is still relevant. I'm not going to tell you that it's irrelevant or just doesn't count for anything. Remember, the DA is very likely to argue in front of that jury that one of the ways the jury can find that you're impaired or too drunk or too high to drive is, hey, look at this collision. This collision happened. Therefore, that's how you know this defendant wasn't safe to drive. Well, if you can show the collision was actually based on other factors other than impairment, you're able to take that argument out, and that could go a long way when you're litigating your case. If not in front of a jury, then maybe during really intense discussions in trying to pre-try the case as well. One other note, remember in our previous video about DUI causing injury, in that situation, how the collision went down is actually relevant to the elements of the offense. Because in order to prove a DUI with injury, they have to prove that the defendant, 1, committed some type of DUI, and 2, somebody was injured, and 3, that the injury resulted in some sort of act of negligence or bad driving that the defendant actually caused, other than simply the DUI. So in a situation where somebody's really, really high or really, really drunk, but while they're driving a car, someone happens to get injured because they just run a red light in front of the defendant, and the defendant was otherwise parked at the time, that wouldn't be a DUI causing injury, because proof that the accident was somebody else's fault does actually negate the proof of a DUI with injury charge, but it doesn't necessarily negate the proof of DUI itself. That being said, how the collision went down might be something that's very helpful to explore when you're defending your collision DUI with your attorney. And you should discuss this issue freely, and maybe even consult with an accident reconstruction expert to fight back against the DA's narrative if possible. If you or a loved one are facing DUI charges in California, please call us anytime at 833-666-5245.